Hello, I'm Jack Balkin, and this is the second session, and I'm going to tell you how it will proceed. First, we'll have three speakers. Each will talk 15 to 20 minutes. I'll introduce them in the order in which they will speak. They will tell you a little bit about themselves, and then they will speak about their topic. Then we will take a break for 15 minutes. When we come back, we have two commentators who will speak, and then we will have multiple questions from everybody. And then after that, there will be wild, frenzied dancing. So, I know that you're looking forward to that. So, first, we will hear from Luisa Cabal from the Center for Reproductive Rights. Then we'll hear from Christina Zampas from the International Reproductive and Sexual Health Law Program at the University of Toronto. And then finally, Maggie Crosby from the ACLU.
Thank you.
Apparently, only one microphone works at a time.
Okay.
There we go.
So, what I'll do today to start the conversation is share and discuss a bill that the Center for Reproductive Rights will be presenting with some allied senators in Colombia to ensure that women can access reproductive health care services while also protecting freedom of conscience. So I'll describe the model in Colombia and some background with regard to how it is aligned with constitutional jurisprudence on the matter, and whether it is aligned or not with regional human rights principles of the Inter-American system, if there are, with international human rights principles, and try to contrast with a few Latin American countries in terms of what are the open debates, the unresolved debates, and the tensions. So I should also mention that I will speak from my experience as an activist at the Center for Reproductive Rights. We're a global human rights organization dedicating to ensuring that women's reproductive rights are protected as fundamental rights that all governments have the duty to respect, protect, and fulfill. So my experience has been from the perspective of documenting reproductive rights violations. What are the consequences of laws that impede or policies that impede access to health services? And our work is mainly exposing these violations and litigating them before national and international bodies. So I'll start with some context of Colombia. Colombia had a complete ban on abortion until 2006, when the Constitutional Court issued a decision decriminalizing abortion under three particular circumstances. If the pregnancy was caused by rape or incest, women's life and health, and when there's a fetal malformation incompatible with life outside the womb. And this decision started outlining the principles under which conscientious objection would operate. It said it's solely for individuals, not institutions, and cannot result in disregard for the fundamental rights of women, and there's an obligation to refer. And so the Constitutional Court has been providing a framework for access to abortion, issuing several decisions on this matter. Because while there has been tremendous support for the decision, there has been, of course, substantive political backlash against the implementation of these decisions. So some of the obstacles in implementing the principles of this decision have been, of course, excessive bureaucratic procedures that in practice have arisen, and very powerful elements within the state, including the Procurador, which is an institution created by the Constitution, which is a defender of the human rights and the constitutional rights, and intervenes before the court and other institutions. He's openly from the Opus Dei and has specifically challenged the access and the operationalization of abortion. So after this decision, there was no regulatory framework for conscientious objection in access to health services. So it created sort of a vacuum in which many things happened that prompted the Constitution to intervene in three different cases. There are three relevant decisions, two from 2008 and one from 2009, that in general developed the following standards. Conscientious objection can only be invoked by personnel directly related to the provision of the abortion services. So it makes very clear that not the administrative personnel. That conscientious objection has to be written, explaining the reasons in the concrete case. That hospitals whose physicians object to undertaking the procedures on the ground of conscience must have on staff by other means available non-objecting physicians. It has established that the health system has a positive duty of ensuring that there are adequate number of providers. And it has, again, very clearly said, again, along the lines that it opened up in the original abortion decision, that conscientious objection cannot be invoked by institutions, that it's only individual. Very interestingly, since judges decided that they would also be conscientious objectors when women were bringing tutelas, which is a writ of protection of fundamental rights, the court had said, well, judges cannot invoke conscientious objection when deciding this access to abortion cases, and they can be investigated under the rules of professional discipline for disregard of the criminal code. The court in this jurisprudence has also established that the Ministry of Health and the Office of Health Supervision or Superintendencia should investigate offending hospitals in light of the regulations established for the legal termination of pregnancy. So one would think, well, that is enough. It seems like the court has established clear standards of what it's expecting. There has not been a regulation developing these standards or trying to operationalize these standards. And the attempt that was made actually to develop through a decree in the Ministry of Health on how abortion services should be provided was challenged by this same procurador. And so this norm was suspended, leaving up in the air the how all of these standards would be operationalized. So in 2011, there was also the backlash was reflected in mobilization towards a constitutional reform process to include the protection of life from the moment of conception, with the idea that then that could result in overturning the abortion liberalization. Simultaneously, conservative groups introduced 4 different bills on conscientious objection in Congress to allow, of course, for institutional objection. That was one of the key elements of these bills. And, of course, opening the parameters of conscientious objection to determine that any health professional could object to any kind of procedure based on conscience. This was not limited to a reproductive health procedure or an abortion procedure. Allies in the human rights and reproductive rights field joined forces with Congress allies in Congress to defeat these proposals and instead try to develop a proactive strategy, not just like let's defend against these 3 bad bills that are being proposed, but then let's make sure that there is legislation that protects those principles that have been established by the Constitutional Court. So there was a bill that we drafted with a set of allies a year ago and was passed by the Senate, but then was blocked in the House. So this year what we're trying to do with a broader set of allies is try to see what are the elements of that original bill that was submitted to Congress a year ago and figure out whether it can move forward under the current legislature. One of the interesting elements that offered an entry point into discussing this in Congress was that the court had mandated Congress to legislate on conscientious objection in the military. So there was a clear mandate that the legislature should act on this. And our allies started discussing with those proposing or working on the legislation around conscientious objection in the military. And since a year ago, we've been working together. So this bill covers conscientious objection in both spheres. What it does in terms of the principles the bill has proposed is the principles that are seeks to protect are the social rule of law around which the Colombian state is organized, and the principles of equality, freedom, human dignity, in accordance with human rights treaties ratified in Colombia. Many of you or some of you might know that our Constitution invokes directly the Human Rights Treaty as part of our constitutional interpretation. So this bill reaffirms that only person and not institutions can invoke conscientious objection. It had to make clear again that judges cannot invoke conscientious objection. And it proposes a national registry for conscientious objectors that would be organized in the Ombudsperson office in Colombia, and that would be confidential. Then this bill has two components, one that is addressed of conscientious objection in the military, and one around conscientious objection in the provision of health services. Again, I won't repeat. It has all the elements from the standards developed by the Constitutional Court, plus this mechanism of the National Registry. And it adds something that the court had left. One of the gaps in the constitutional jurisprudence was that conscientious objection cannot be exercised in emergency cases when the life or health of the woman or the patient are at stake. So this legislation tries to introduce this. So then the question is, well, is this bill being proposed and these standards aligned with regional and international human rights standards? And when you look at the American Convention, of course, the Article 12 provides for the rights to freedom of conscience, which might be subject only to the limitations prescribed by law that are necessary for public safety, order, health, morals, or the rights and freedoms of others. The interesting thing is that the jurisprudence of in the inter-American system offer very little guidance on conscientious objection in the healthcare system. There are 3 decisions on conscientious objection in the military, which don't really provide much from which what we can interpret well whether the Colombian bill could be aligned with that. What is interesting, though, is that the Inter-American Commission on Human Rights does issue thematic reports, interpreting and trying to see trends in the region and guide interpretation or potential future interpretation of articles of the convention. In 2010 or in 2011, it issued a report on access to information with regard to reproductive health services. And in this report, actually, it tries to develop, given that there's this gap in their own jurisprudence, of how they could address conscientious objection in the health system. And then they said that they recognize that freedom of conscience can collide or be in conflict with the freedoms of patients. And so it tries to push for resolving these tensions through referral, to the obligation to refer. It also points out that governments do have a positive obligation to ensure the right of conscience, but also to organize and guarantee, organize the health services in such a way that it guarantees access to those. It also makes explicit that conscientious objection cannot be a mechanism of discrimination and violation of fundamental rights of patients. And what it then does is cite and brings, since it has very little guidance from its own system, it brings the interpretation of the Colombian Constitutional Court so as to endorse it. So it sort of repeats what I've already said in terms of duty to refer, that it's individual, non-institutional. The question there is, by citing it and sort of endorsing it, is it saying that within the American Convention, one could only protect individual conscience, and making that explicit? That's an interesting question. With regard to the UN, And something to also point out with regard to this report on the conscientious from the Inter-American Commission, it always refers to patient rights, but it never analyzes the gender dimension of who's accessing these services, right? It's just gender neutral and never sort of questions that it's about, but probably about gender discrimination. When one looks at the United Nations standards, there is some, but not much with regard specifically to this issue. One could find concluding observations from CEDAW, or the General Recommendation 24 on Access to Health, which sort of, one could see that they all affirm that there's a duty to refer, that governments must, while protecting conscience, ensure non-interference with other fundamental rights, such as women's rights, but it is the special rapporteur on the right to health that further developed, the interpretation of what it means or what are the parameters. And it further stated that it should not be allowed in emergencies, or those are the limits. And it emphasizes, again, the positive duties to ensure access to women's sexual and reproductive rights and services. So then, the question in Colombia, well, I want to point out to some of the debates that have been going on, but also within the Latin American context in some of the countries that we have looked at, where there are countries where definitely established that conscientious objection is personal, under only individual and not institutional. Mexico City's regulation seems to imply that by saying that the right holder is the health professional. But Argentina, and more recently in Uruguay, allow for institutional sort of conscientious objection in institutional settings. The most recent, and I'm mentioning Mexico City, Uruguay, and Argentina to a certain degree, in Uruguay and Mexico City, because there have been relatively recent reforms to liberalize abortion laws. And in Argentina, jurisprudence from the court trying to open at least the interpretation in terms of the rape exception. What Uruguay tried to do was they introduced a legal figure that they call objeción de ideario, like ideological objection from an institution, but it's very limited. What they're trying to say is like, okay, we'll accommodate institutional conscience, but the way they regulate it is that private health institutions, based on their statutes, within 15 days after the law was issued, can register and explicitly say that they will refrain themselves from practicing abortion services. So they try to contain it. So for us, the question is, the debate is open in Latin America, right? There's this tension that doesn't seem to be resolved, and the question is, what is going to be the trend for other countries? There's also the question of whether auxiliary staff, what happens with auxiliary staff. The Constitutional Court of Colombia makes it explicit that it's only those directly intervening in a procedure, whereas some regulations in Argentina allow for auxiliary staff to object. One of the debates currently in Colombia, even within our allies, are the question about the national registry and how to regulate, how do we ensure that the health system and those providing, the insurers or those providing, how can they ensure that there are available physicians within the health system if it's not by actually having a confidential database where you can know who is objecting or not. Uruguay's approach to that was not having a national registry, but within the hospital. It's managed within each hospital. Some of our allies that actually provide reproductive health services have actually said what this can create is harassment towards health professionals that want to provide abortions to go and register in the registry. what we have seen actually is, of course, hospitals have tried to object as institutions, but what we have seen is the opposite. Harassment towards actually signing contracts, establishing that they won't provide services, not only in that hospital, but generally. The other question, so that's the question, how does one regulate it, preserving confidentiality, and preventing harassment? But the other question that we have seen, and I think it has been documented in Mexico City, is those providers that object by day but provide by night, at night. So you declare yourself to be an objector in the public hospital during your 9 to 6 duties, but then go to your private practice and, of course, earn triple the price after office hours. So how is it that you deal with these issues? How can the law or the regulatory framework address this issue? And then the last, and the interesting thing about some of the regulations in Argentina as well is there's a technical guidance that mandates disclosure from whether it's the secretary, the provider, the nurse, from the moment the woman comes into the hospital, for example, seeking the service. The question there is it a violation of the right to privacy? Is it a right balance of protecting the women's access to the service with this forcing the provider to disclose or the nurse to disclose that they're objectors? It's a question, but that's something I found in the regulations in Argentina. And I guess my last point to open the conversation would be with regard to human rights standards that apply to the right to health. One of the general comment of the Economic and Social Rights Committee has established that one would look at accessibility, availability, acceptability, and quality. And very clearly in the Colombian court and in Mexico City, it has been clear that the governments need to secure that there are enough providers, right? It has made it very clear. But when one looks at availability, clearly that's in alignment with ensuring that piece of the right to health. The question is, can institutional objection be allowed when one looks at guaranteeing the availability of services? In particular, in looking at Latin America, where there are only maybe one provider in a town. So is it just enough to ensure that there are providers, or to meet that availability standard, would it be incompatible with human rights standards to allow for institutional objection? That's a question in terms of the availability of services in practice. So I'll leave it there.
That was great because, is this on? I'm going to be raising, can you hear me? Okay. I'm going to be raising a lot of the same issues that Louise was raising, but in the context of Europe. And I'm really glad that the organizers asked for someone to speak about Europe, because oftentimes we think about Europe and we don't think that there are huge problems in terms of access to abortion, with the exception of Ireland, of course, and Poland. But in actuality, these issues of conscientious objection are really arising a lot in Europe lately, and it's not just in Poland or Ireland. It's happening actually across the continent. So I'm going to be speaking a little bit about some of the same challenges that Luisa raised and how European law has responded to that, national level law and some jurisprudence at the national level, and then look at what the European Court of Human Rights has said about it. But before, I just want to thank all the organizers for having me here, and I just want to say last time I was at Brooklyn Law School was almost 20 years ago, and I was studying for the bar exam here. I went to Syracuse, but I came back to the city and I took the Barbary Cross at the Barbary course at Brooklyn Law School, so I don't have such great memories of this place, but it's really nice to be back, even though these are very complicated and difficult issues, to be back at Brooklyn Law School so many years later. And I'm a fellow at the University of Toronto at the law faculty there, doing some work on conscientious objection with Rebecca Cook, and I also do consultancy work with UN agencies on reproductive rights issues, and before that I was at the Center for Reproductive Rights for 10 years directing their Europe program, and I've taken a lot of the cases with the Center's partners to the European Court of Human Rights on conscientious objection and abortion. So that's a little bit about my background. And I just want to start that basically, I don't know if everyone's familiar with abortion law in Europe, but you have pretty liberal regimes with the exception of Ireland and Poland, which are pretty restrictive. Ireland only allows abortion in cases when a woman's life is in danger, and in Poland when a woman's life and health is in danger, and in cases of fetal impairment and in rape. But in most other countries, you have abortion on request available between up to 10 to 18 weeks. So you're seeing actually conscientious objection arise a lot in these liberal, more liberal countries as well. And they almost all European countries have laws allowing for conscientious objection. And you usually find them either in general health care laws or in specific laws governing abortion. A few countries don't have laws at all, but they rely on their medical ethical codes to regulate the practice. And while these codes are not legally binding, they're often persuasive authority for the courts in those countries. And that's the case of Romania, for example, and in Sweden. And the scope of the clauses really vary from country to country, so we can't really have this broad generalization about what the conscientious clauses cover across Europe, but a lot of the regulations are very vague, and some of them basically can be interpreted to allow any health professional to object to participate in any medical procedure that is against their conscience. Others are, like the Norwegian law, is very, very specific, and it also sets forth obligations on healthcare institutions to ensure an adequate number of providers willing and able to perform those services. But the implementation of those laws are a different story. But surely none of them are comprehensive enough to address really the wide range of healthcare contexts in which conscientious objection is invoked. The lack of regulation and oversight of these laws allow providers to evade referral requirements. They become very difficult to enforce. And in countries with restrictive laws, the criminalization of abortion and the stigmatization of abortion create a real chilling effect for providers that might be willing to provide abortions but feel peer pressure not to from colleagues, or worse, they fear prosecution for actually performing a service that may be deemed illegal. And in recent years, there have been really a lot of increasing attempts across Europe to restrict access to abortion, including through law reform, but also including through increased pressure on providers and institutions to invoke their conscience in abortion cases. And this is due to a number of factors. One is the increasing influence of the Catholic and Eastern Orthodox churches in the development of laws and policies, growing populism that we heard about earlier when we were speaking about the attire cases across the continent, a rising European-based anti-abortion movement, and continuing backlash against communism. And I'll give you an example, the example of Russia, which is in the news now a lot. In 2011, they passed restrictions to their abortion law, and it was basically a nod to the Orthodox Church and in support of traditional values in Russia. And it is the first law in Russia that explicitly allows for the practice of conscientious objection in the abortion context. It came in combination with other restrictions, including a really long waiting period of 7 days, biased counseling requirements, but there have been no regulations issued about how the practice should be monitored. So we don't really know exactly how it's being implemented or what's happening in practice. And a recent case taken by the Center for Reproductive Rights and the Federation for Women and Family Planning in Poland kind of illustrates the context in which conscientious objection occurs in. And I think it raises a lot of the issues that we see, maybe not collectively as we see in Poland, but individually arise across the continent. And the case concerns a 14-year-old girl who was raped and who became pregnant. And she was entitled to a lawful abortion in Poland, but she couldn't get one. She eventually got one, but it was severely obstructed. Supported by her mother, she traveled around the region that she's from, visited 3 different hospitals, and she received deliberately distorted information on what the requirements were for obtaining an abortion in cases of rape. One of the hospitals disclosed her personal and medical data to the press. She was harassed by doctors, anti-abortion groups, and representatives of the Catholic Church. Individual doctors and whole institutions invoked conscientious objection without referring her to another provider or hospital, which is part of the law. The hospital staff, a priest, and police asserted that the mother tried to coerce her to have an abortion, and she was taken from the custody of her mother for 1 week and placed in juvenile detention. This is all happening, and Poland has a 12-week period for abortion in cases of rape. And at the end of the day, what happened was that this became a huge issue in the press in Poland and actually across Europe, and the Ministry of Health finally intervened in the case. And what they did was they picked her up from her home, drove her 500 kilometers to Gdansk in northern Poland, where she received an abortion, but essentially it was a clandestine one. She was never registered in the hospital. She was not given any information about the procedure, not even told that she was going to go under anesthesia. She wasn't given any post-abortion information or care, and she was told to leave the hospital immediately after the procedure. So this might be an extreme case, but like I said, I think it raises some of the challenges that we see on the subject in Europe, and I'll be looking at 6 of those challenges, much of what Louisa has also raised in the context of Latin America. And this issue about ensuring the availability of healthcare providers for sexual and reproductive health services, especially abortion, is, I think, a growing problem in Europe. In Austria, for example, there are no doctors performing abortions in Salzburg, which is the 4th largest city in Austria. Doctors from Vienna travel 300 kilometers every weekend to provide abortions there. A recent report by Italy's Ministry of Health revealed that 70% of gynecologists in Italy refuse to perform abortions on moral grounds. And 70, and that between 2003 and 2007, the number of gynecologists invoking their conscience rose from 58.7% to almost 70%, and that in the southern parts of the country, the numbers are even higher. But only a few countries actually require notification of their objecting status prior to or in early stages of employment, and even few require that job recruitment require that they perform abortion. So the laws is not great in this area, and I think that there's a lot of gaps in terms of availability of providers, although very little has been documented. Italy is one of the few countries that actually keeps statistics on conscientious objectors, and this is one of the challenges that we see. In Norway is one of the few countries that have a really pretty good regulation on conscientious objection to abortion, and it does require healthcare providers to give written notice to their employer hospital at the time of employment and those hospitals in turn to report this information to government authorities, and government authorities have to make sure that there's a provider in every single hospital available all the time to perform abortions. Furthermore, the law in Norway says that employment advertisements may require and advertise as a condition for employment that hired healthcare personnel be willing to perform or assist in abortion procedures. So Norway's always giving the Norway example. But we'll see that it's also problematic in practice. The issue of institutional objection is also a growing issue in Europe. And laws generally don't explicitly prohibit this practice. And there is little, if any, oversight or monitoring. Women are often turned away and denied health services because of a decision of a director of a hospital or the head of a gynecology department not to perform abortions. So this leaves the less resourceful women unable to travel, women living in rural areas, poor women, especially vulnerable. And in some countries, insurance plans are limited geographically. So this causes problem for women to actually get services outside of their geographical area without prior approval, which takes time. In Romania, for example, at the behest of local churches and anti-abortion activists, numerous public hospitals across the country, including in rural areas, refuse to perform abortions altogether. And these are public hospitals, and many more hospitals suspend abortion services for days or even weeks during Christmas and Easter holidays. It's very common. A 2001 decision by the French Constitutional Court, I think, is a very useful one and has been used against this practice of constitutional objection across Europe. It recognized that the principle of conscientious objection is a right afforded to individuals and not to institutions. And there was this case that was brought by senators who claimed that the repeal of a provision of the Code of Public Health, which allowed department heads of public health institutions to decide whether or not to perform abortions in their facilities, violated the principle of freedom of conscience protected by the Constitution. And while the court recognized the fundamental nature of the freedom of conscience, it's also clarified that such freedom was that of an individual, not institutional or departmental, which cannot be exerted at the expense of that of other doctors and medical staff working in his service. The council also said that the provisions of the health code contribute to respect for the constitutional principle of equality of users before the law and before the public service, and upheld the repeal of that provision. The next issue, which is similar to what Louisa also raised, was regarding ensuring conscientious objection is exercised in the direct performance of services. And there's a lot of cases arising, anecdotal evidence that it's arising a lot even amongst some janitorial staff. And while a lot of legal frameworks are unclear on what type of healthcare staff can object and for what services, some clauses state either explicitly that they apply only to healthcare personnel involved in the actual performance of the procedures, or have been interpreted as such. For example, the scope of the conscious clause in the UK's abortion law was clarified by a House of Lords decision in 1988, and the case involved a secretary who objected to signing an abortion referral letter on grounds of conscience. And the House of Lords held that such an act did not constitute part of the treatment for abortion and thus was not covered by the conscious clause of the abortion law. And we're seeing generally that I think some of the jurisprudence in this area is becoming clearer and clearer, and the laws are actually, I think, becoming a little bit clearer possibly in this area. And they do support that the proposition that healthcare providers cannot have a duty to perform the preparatory steps to arrange an abortion. So it's not just that ancillary staff can't object, but also that providers themselves must also help women to get abortions if they are objectors, so that they have to refer them to a provider really willing to perform the services. But we are seeing cases where actually providers are raising objections to referral. So they're saying that it's against their conscience to refer a woman for an abortion, and therefore they just keep silent. And there's actually a recent case in Denmark where a woman was scheduled for an appointment to undergo an abortion, but was not informed by the doctor of his objection, and nor was she provided a timely referral. And a member of the Danish Board of Health and a legal commentator noted that what the impact could have on her right to abortion, which is basically if you only allow abortion on request up to 12 weeks, and you have the situation where it's unclear if the doctor's an objector and you're not referred, you're basically foregoing your right to an abortion. And there's also a recent case in Spain, in Malaga, Spain, in southern Spain in 2011, where a family doctor invoked conscience on refusing to refer. And again, the judge in this decision, which came soon after the liberalization of the abortion law in Spain, established that as a public employee, his duty to provide adequate health care prevailed over that of conscience. And the UK National Health Service guidelines note that doctors who fail to quickly refer women could be in breach of their terms of service. And a corollary duty is to really ensure that women will receive quality care, so it's continuity of care also. And although there isn't a lot of case law on this or much discussion, actually, I think it is an issue of if a healthcare provider cannot provide an appropriate referral, does the healthcare provider have an obligation to perform the service, whether or not it conflicts with his or her conscience? That's an open question. And of course, there's a duty to refer in emergency situations, and you see that in laws and ethical codes, not just on abortion, just the general duty to refer, the general duty to provide services in emergency situations. But actually only 11 countries in Europe expressly prohibit the invocation of conscientious objection in the case of emergency or risk of death, as well as a danger to patient's health. And so this is an area of law that really needs to be developed. And we saw, I think it was probably in the news here too, the case of Savita in Ireland, who died because she was refused an abortion, I think in part based on conscience. There was other issues there as well. And I think there's an open question whether or not there should be conscientious objection should be allowed in countries with really restrictive laws. If you only allow abortion in cases when a woman's life or health is in danger, you really shouldn't allow conscientious objection at all, period, I think. But you see it arise even in countries in Africa that have really restrictive laws. And finally, there's a duty to provide accurate and non-biased information about a patient's health status and available procedures. I was going to mention a UK High Court case, but actually the European Court of Human Rights recent cases highlight this duty. So what we're seeing happening is doctors not telling patients about their high risk of potentially carrying a baby with a fetal abnormality because of their age, or not allowing them to get genetic prenatal examinations because they're concerned that the test results will lead to an abortion. And that was actually a case at the European Court that the center worked on. I have time to mention the two court cases?
Very quickly.
Okay. So actually there's a lot happening in Europe at the European level on conscientious objection, including from the European Union and Europe's human rights system, the Council of Europe. But I'm just going to mention the European Court of Human Rights cases. And like many international and regional human rights treaties, the European Convention guarantees the right to freedom of religion, conscience, and thought. And under convention case law, the freedom to manifest one's religion or beliefs can be limited on numerous grounds, including the protection and the rights of others. including the right to private life, which is where we see much of the court's abortion jurisprudence arise under. And the European Court of Human Rights has only addressed conscientious objection in reproductive health care settings in 3 cases. 2 cases are very recent. They're abortion-related cases, 2011 and 2012. And the first case was actually an admissibility decision from 2001 regarding pharmacists and their refusal to dispense contraceptives. I'll mention the abortion cases first, since that's what I'm focusing on. And those are the cases that I'm most familiar with. I worked on those cases at the center with Louisa and others. So the 2011 case is called RR versus Poland, and it was a case regarding a woman who was obstructed from getting a genetic prenatal examination after her sonogram indicated that there was potentially some severe chromosomal problems and potentially a fatal fetal impairment. Numerous doctors refused to provide her with the tests for fear that the results would lead her to decide to undergo an abortion. The case was taken to the European Court, and numerous claims were made. Conscientious objection was one of them, and actually we were really surprised to see that the court even addressed this issue, because during the proceedings, and I'm talking about written proceedings, the court never asked a question of the state or of the party about conscientious objection, even though the claim was made and we raised it. And so we were really shocked and pleasantly surprised, even though the decision was kind of limited, to see that the court actually addressed it. And it addressed it in the context of the importance of the right to information, a patient's right to information. And it noted that her access to genetic testing was marred by procrastination, confusion, and the lack of proper counseling and information given to her. It made clear that the access to diagnostic services was decisive for the possibility of exercising her right to make an informed decision as to whether or not to seek an abortion. And it noted the crucial importance of timely access to information on one's health condition, stating that in the context of pregnancy, the effective access to relevant information on the mother and fetus's health, where legislation allows for abortion in certain situations, is directly relevant for the exercise of personal autonomy. And it noted that effective implementation of abortion laws is important for ensuring the right to lawful abortion. And it basically asked Poland to organize the health service system in such a way to ensure that an effective exercise of the freedom of conscience of health professionals in the professional context does not prevent patients from obtaining access to services to which they are entitled under applicable legislation. This was the first time that the court actually articulated a state's positive obligation to regulate the practice of conscientious objection in reproductive health care settings. And while the reasoning is really scant and not detailed, which is often the case at the court, as Ava probably knows well, it did lay the groundwork for the court to actually build on this jurisprudence a year later in the case that I mentioned about the 14-year-old rape victim. And so the court went beyond what it said in RR and said that it also condemned the state, which it didn't necessarily do. It just kind of threw in this one paragraph on conscientious objection in its decision without really discussing it at all. But in the PNS case, it did discuss it more, and it said it basically condemned the state for failing to implement its own laws governing conscientious objection and the right to information, and it laid out some minimum safeguards to ensure patients' access to legal services. At the very least, refusals must be in writing, they must be included in the patient's file, and the objector must make a referral to a non-objecting provider. And there was no discussion of the gender context, no finding of a violation of the right to non-discrimination on grounds of sex, nothing like that, just treated her as a patient, as we saw the human rights system in Latin America is addressing it as. And then finally, I just want to mention this French pharmacist case, because this is the case that everyone cites to, and people in the reproductive health field are like, isn't it wonderful? This is a great decision. Actually, it's an admissibility decision, and it was from 2001, and it was a case regarding 2 pharmacists in France who were required under French law to dispense contraceptives. There was no exemption for conscientious objection under the French law. And basically, they brought the challenge to the European Court of Human Rights, arguing an Article 9 violation, a violation of their right to religious freedom. The court decided on admissibility. It basically said that there was no claim to be made in this case. And it found that the convention, which guarantees the right to freedom of thought, conscience, and religion, protects acts closely linked to personal convictions and religious beliefs, such as acts of worship, teaching, practice, and observance. However, it noted that Article 9 does not always guarantee the right to behave in public in a manner governed by that belief, and that as long as the sale of contraceptives is legal and occurs on medical prescription nowhere other than in a pharmacy, the pharmacist cannot give precedence to their religious beliefs and impose them on others as justification for their refusal to sell such products, since they can manifest those beliefs in many ways outside of the professional sphere. I think the court here was really emphasizing the fact that they had a professional public duty, and you can't get contraceptives in any other place but a pharmacy, and if we were to allow you to conscientiously object or recognize that right, essentially it could create an atmosphere where women can't get the services. And I think, in summary, if you're trying to reconcile these cases, the Polish cases and the French case, and what I think the court is saying is that if the state doesn't allow for the exercise of conscientious objection, where a public service is being provided, it's not necessarily a violation of the right to religious freedom or conscience, as long as that right can be manifested in other ways, and what you're providing is a public service. But when the state does allow for conscientious objection, it must ensure that the practice doesn't hinder the exercise of other rights, and in this case, the right to access lawful services. And I just want to say that as we see in the case of Latin America and in Europe, there's a lot of gaps in the law. There's a lot of gaps, I think, in national law as well as international and regional law. And there's a lot of work to be done in developing the standards at the national and international level. And I think one of the things that needs to be done is gathering more of the impact that such practices have on women's access to health care. There's very, very little documentation done, except for the individual cases that we're hearing about, as to what sort of impact conscientious objection has on women's access to services. And that's often what we hear from the opposition. They say, like in the case of Italy, so what? Women, you don't know if there's any problems. Show us that there's problems actually in the fact that 70% of gynecologists are performing abortion. So we need more research in that area, both, I think, from the human rights field, but also from the medical and health fields.
Thank you. Am I on? Can you hear me? Okay. Well, thank you. It's really a privilege to be here, and thank you all for the human rights work that you're doing all around the world. I've been finding it inspiring to hear about it. I work for an affiliate of the ACLU in California, and we affiliate lawyers tend to be generalists, so I work both in the area of religious freedom and reproductive rights. And from that dual perspective, looking at the laws in America today that shield institutions and providers from the consequences of performing abortion care, I can say that equality is the big loser no matter which side of the equation we look at. The people who support very broad refusal laws in this country frame it as freedom of religion versus abortion, and will go on to say that in any clash between freedom of religion, which is America's first foundational freedom, and abortion, which many don't recognize as a right at all, that conscience must prevail. But the truth is that today politicians are invoking conscience as a justification for passing laws that are really about stigmatizing abortion and creating barriers to its access. Because in this country, there are many laws that protect institutions from providing abortions, and they are barring their staffs from providing these services, even though there are many doctors and nurses and health professionals who feel ethically obligated to provide comprehensive reproductive health care. And yet we don't see politicians caring about their conscience. So it's not a principled invocation of conscience rights. To me, religious freedom itself embodies an equality concept. It means government neutrality. It means that from a constitutional perspective, minority faiths and majority faiths should be equally protected, that a secular conscience that occupies the same place as religion should be equally protected. But what we see in America today is that the conscience that gets protected is the one that happens to align with the prevailing political ideology, and that is opposition to abortion. And certainly equality is the big loser on the other side of the equation, which is women's rights, because, as we know, control over childbearing is critical to women's participation in the economic and political and social life of the country. So where are we? Health policy in the United States is generally a matter for our state governments. But abortion is so contested and so controversial that, in fact, there are 3 major federal laws Congress has passed on the subject of religious refusals. And they came in at different decades, and you can really see a progression in how aggressive and anti-abortion the laws became. So the first one, known as the Church Amendment after its author, Frank Church, was something Congress passed just a few months after Roe v. Wade legalized abortion. And actually, he introduced it to respond to a court ruling that said that a hospital that received certain public federal funds had to provide sterilizations. That was in 1972 before Roe. And so he said, as he introduced the bill, the fact that you receive funds does not mean that you have to provide abortions or sterilization. He also introduced a clause that said, and if you receive those funds, you can't discriminate against healthcare providers because they refuse to perform or assist in the performance of an abortion. But as Congress passed that law finally, it was a two-edged sword. It also said that you can't discriminate against a healthcare provider because he or she does provide abortions or does advocate for abortion rights. And what's interesting is that Jack Balkin has written that there was a time in this country before we had he calls a political calcification around abortion rights, because now, today, with our major political parties, the Democratic Party is the party of abortion rights, the Republican Party is very much the party of fetal rights. But Frank Church was actually a liberal Democrat, and the protection for providers who do perform abortion came from Jacob Javits, who was a liberal Republican from New York. So that's an alignment you would never see again. And unfortunately, because the courts have said that there's no private enforcement of that law, it actually hasn't come to protect providers who are willing and unable. But that was the decision Congress made back in the 70s. Fast forward to the 1990s, where the accrediting agency for graduate medical education, the residents basically who are learning to be young obstetricians, said, you're not going to get accredited if you prevent your young residents from learning how to do abortions. Shouldn't surprise us, right? The idea that a doctor whose expertise is managing pregnancy ought to know how to end one. And we're talking about willing doctors. We're talking about what the agency said is you have to either train them in your facility or let them go someplace else, Planned Parenthood, to learn how to do abortions. Quick like a money, Dan Coates, we call it the Coates Amendment, Congress passed a law saying that the state governments could not, quote unquote, discriminate against these unaccredited medical schools simply because they would not allow their young residents. Again, it's very competitive. I mean, you just may end up someplace that will not train for abortion. And then finally, on the federal scene, there's something we call the Weldon Amendment, and this came in 2005. And it started its life as a freestanding bill drafted by the major anti-abortion organization in the United States. Now, I'm an advocate. I have drafted wish list bills myself They don't usually pass in their extreme form. And indeed, ANDA was just going nowhere until it was attached as an amendment to the major domestic appropriations bill. Something I would have called a must-pass bill, although right now it appears Congress doesn't think it has to pass an appropriations bill, but it has shut down the government. But Weldon basically is a wish list, and it protects any institution from any state law for refusal to provide, perform, cover, pay for, or refer for abortion. And what that means, attached to our labor, education, and health bill, is my home state of California stands to lose $38 billion a year if it enforces, for example, its law requiring religious facilities to provide abortions in an emergency. It means that our Attorney General, which supervises hospital consolidations, cannot refuse to approve a transaction because it will wipe out the availability of abortion services in a particular region. California is a very big state. There are big rural areas where it's very difficult to find a provider. That's the federal scene. There's been a similar parallel progression in the states. Actually, after Roe versus Wade, virtually every state passed a law that said that people didn't have to perform or participate or assist in abortion procedures. And those laws kind of nestled quietly in the statute books. They didn't really mean anything because they only mean something if there's a duty to perform the services. And the Supreme Court very quickly ruled that even public facilities don't need to provide abortions, much less private hospitals or certainly religious hospitals. And in the kind of pluralistic healthcare system that we actually had in America in the early 70s, it doesn't really matter whether the little Catholic, hospital down the street does something or doesn't, because there are a lot of choices. But that's not the healthcare system we have. And so in the 80s, what you saw was a growing consolidation. You saw managed healthcare. There were provider and payer integrations. So quickly, patients didn't have choices anymore. And they were very unhappy about running into what were called medical gatekeepers or insurance gatekeepers. They were also running into the religious gatekeepers, where they had to get their care at a religious facility that did not allow for reproductive health care. We also had changes in the law because we had in the late 80s the United States Supreme Court, which had balanced religious rights with other state interests when adherents were finding that their faith conflicted with secular laws, like a no hats rule, but a devout Jew wants to wear a yarmulke, that kind of thing. It used to be a balance. Supreme Court said, no more exemptions for neutral laws. Religious adherents, they said, go out and lobby for exemptions. Well, that's all well and good if you're a majority faith with political clout. For the minority faiths in this country, it's really kind of left them high and dry. But it was certainly the case at the Catholic Conference, and like-minded allies against abortion started lobbying very aggressively in the states on abortion refusal. And they were running into us, into the advocates who were trying to create duties like a duty for insurance to cover contraception. That particular issue is actually heading right now to our U.S. Supreme Court. But what we saw was a new wave of abortion refusal laws that, were extremely expansive. They went well beyond what actually the professional organizations that represent health professionals think is an ethical obligation on their part. So, for example, the American College of Obstetricians and Gynecologists says that there is a duty to give complete and accurate information and to refer. The Pharmacists Association makes, I love this phrase, a nice distinction between the right of the individual pharmacist to step away and the pharmacist stepping in the way. But the laws that we saw very much allowed institutions and individuals to step in the way and to refuse to give referrals and refuse to allow their staffs to provide the services. So when we look at this picture, again, through an equality lens, certainly it's had an enormous impact on women's rights to access abortion. I mean, this is a time in the United States where states are tripping over themselves to pass the most restrictive criminal laws. Well, we're going to ban it at 18 weeks. Well, we're going to do a heartbeat, and so in that context, you can see these refusal laws, and I think people tend to, as relatively benign. But that is not the case, again, given the structure of our healthcare system. 1 in 9 hospital beds in acute care hospitals now are Catholic-owned facilities. And while most women don't get their abortion care in hospitals, when they do, they really need the facilities of a hospital. I mean, something desperate is happening to a woman who is very, very ill. She's usually losing a wanted pregnancy. And the fact that her doctor is barred from giving her the care she needs is the stuff of headlines. But I want to tell you, too, that in a more subtle way, these refusal clauses, especially the institutional refusal clauses, are having a real impact on women's access to early abortions even. And there's a fascinating study that was done by a woman named Lori Friedman, and she looked at what happened to, it's called Willing and Unable. She looked at people who had gone through what's called the Ryan residency programs, which train on family planning, including abortion, and that many of them several years later were not providing abortions. And why was that? And what she saw was that these corporate entities, the practices, the payers, were barring them from providing abortions. Again, not even for religious purposes sometimes, but simply because of the corporate aversion to controversy. And that, they're young doctors, right? They don't have clout in the marketplace as against their employers. Many of them had moved to the Midwest, for example, to be near family. Ironically, the feminization of the profession made it worse, not better, because these were women who were themselves like young mothers, and so they had to be near family to help. And therefore, there weren't kind of husbands at home to take care of the kids. I mean, they wanted to work for practices where their hours could be somewhat controlled. Well, those tended to be places that told them, fine, you're not doing abortions. And so, you have this impact on women's access and this impact on provider conscience. And so, again, looking at it from an equality lens, it seems to me that on both the conscience side and the women's equality side, we have a system that is antithetical to equal treatment. On the conscience side, again, we don't have politicians in this country rushing to defend people who won't do their jobs if it's a minority faith. One of my favorite stories was in Michigan, which has a large Muslim population. There was a news article that disclosed that many very devout Muslim taxi drivers, and apparently this was something, there were many Muslim taxi drivers, at the airport were refusing to transport people if they had alcohol with them. So you had these people coming from Napa County, with their wine, and the taxi drivers would say, I'm not taking you anywhere with the alcohol. Well, people were outraged. I mean, no one said, oh my goodness, this is a conscientious refusal. We ought to be protecting, their right not to transport people with booze. And you see, but you do see it in a very comparable situation with abortion. There was a Minnesota delicatessen, for example, that would not deliver sandwiches to the Planned Parenthood because they didn't like what they were doing inside. That the connection between the sandwiches and the reproductive health is obviously very, very attenuated. And yet that got the protection of the state's highest court as against a challenge under the public accommodations law. And I think, again, we test our commitment to, is it a principled commitment to religious freedom? Well, we test that by saying, do you do it for the unfamiliar tenets of minority faiths? And the answer is we don't. And I'll end by saying, looking at the perspective of women's equality, it's really a terrible situation. Most particularly, of course, in the concrete way in which it's become a real barrier to women's access to abortion. Particularly, of course, thinking about equality, the young women, the poor women, the women who have to travel, the people who most need, I would say, the protection of a constitution. But I want to end, too, with the thought that, and it was stimulated by our discussion this morning about the veils, and, are women really smart enough to choose the veil? Are they being coerced? Well, if you don't think women can choose their dress, you certainly don't think they can make choices about childbearing. And indeed, one of the criticisms I think many of us have about Roe versus Wade, which struck down criminal abortion laws, is that it was much more about the doctor's right than the woman's right. And indeed, by talking so much about a woman's decision in consultation with her doctor, kind of laid the seeds for this idea that the woman needs the doctor to make the decision, that she can't make her own decisions about pregnancy. And that, that where is the grown-up in the room? And we see that playing out, again, with a lot of restrictive laws about waiting periods and counseling, distorted counseling and things. But you also then understand why symbolically these refusal laws are very important for the anti-choice movement, because it's like, the person who can really make the moral decision doesn't want to make that decision, and therefore it morally discredits the woman's decision. And I'll end with, and I'm saying this in part because we're so thrilled that this happened, we've been working in California for 10 years on the research protocols and finally culminated in a bill that would allow nurse practitioners, certified nurse midwives, and physician assistants, our allied health professionals, to do first trimester aspiration abortions. And just as I was getting on the plane, our governor signed that bill, and we're very, very happy about that in terms of making abortion providers available in, again, what's a very big rural state. But I will end by telling you about a political cartoon from an opposing newspaper when the bill was going through our legislature, where they had a panel that said, Roe versus Wade, abortion, a decision a woman makes in consultation with her doctor, and then it says, AB 154, a woman's in consultation with her nurse practitioner or her physician assistant, as though, again, it's somehow a morally discredited decision because, where is the grown-up in the room? Where is the guy? Where is the doctor?
I am been given a piece of paper that says that the coffee break is ready upstairs. So let us all adjourn for 15 minutes. We will reconvene at 3:35. We're going to get to the commentators in a second, but I thought what we'd do is we'd start with a very short question addressed to the first three speakers. It's a comparative question. I was going to start by asking Maggie, having listened to the accounts of the various issues in Latin America and Europe, of course, these are countries with a positive social democratic tradition, very different from the American libertarian tradition. I was going to ask, was there anything in what you heard, despite all the problems that they were reporting, was there anything that you heard that you wish you had in the United States?
Oh gosh, I think it's like the golden era over there compared to where we are in this country. Not only because these are countries where the government actually seems to fund health care for people who can't afford it otherwise. We haven't even talked about the fact that in this country there's no public funding for abortions and a huge hardship for poor women. But even looking at the way in which the countries have ameliorated the hardships of recognizing refusals is light years from where we are. So, for example, on the issue of having to notify patients of limitations, certainly that's understandable when there's a short time period for exercising the right. But, in this country, we have a whole string of what are called crisis pregnancy centers that are often very misleading. People think they're getting regular health care, and they don't understand until after they've gotten counseling that abortion's going to cause infertility or breast cancer or whatever, that they're actually getting an ideological and not a medical message. And the very few places that have tried to deal with the misleading character of that by saying you have to post a sign saying you don't counsel or refer for abortion or provide it, courts have struck them down for the most part. So I think in many ways the negative rights libertarian character of American constitutional thought has left women, even farther behind than what I'm hearing from our sisters in Europe and in South America.
And I'm just going to ask the question first to Christina and then to Louisa. Is there anything in this libertarian tradition that you would find useful at all? We were talking before, and they sort of looked at me and said, no. But is there anything that's valuable that could be useful to you in either the Latin American or European context?
Hi. I think this theoretical right to an abortion in the U.S., which doesn't exist in Europe, really. There's no right to an abortion under European constitutional law on the subject. So this very fluffy right.
I've never heard it described as a fluffy right. But now
well, I guess not. Well, from a European perspective, where we do have positive obligations, which is very different than in the U.S., and we were talking about that earlier with Louisa. I mean, I think that's like the main difference, is that there are positive obligations to ensure that women have access to lawful services, such as abortions. And the European Court has a really great phrase it uses when the state has refused or doesn't provide, doesn't take measures to make sure that rights are realizable. It basically says that rights are not theoretical or illusory. Rights should not be theoretical or illusory, but practical and real. And it's actually used this phrase in all the abortion cases as well. When a state realizes or has legislation which allows for abortion, it must make that right real. And I think that we don't have that in the U.S.
We don't. Okay, there you go.
I think it's similar to what Christina said, that of course it's very powerful to be able to say in the U.S. there's a right to an abortion, however illusory it's becoming or not. Mm-hmm. And it still has relevance. The Roe decision even still has relevance. There was a case we litigated in Nepal, and the decision came down a year or two ago, where the Supreme Court of Nepal was still referencing Roe in its justification in terms of continuing with that sort of right to abortion notion. So it still is very powerful, and unfortunately our framework, similar to Europe, has been one of exceptions, and through the carving of exceptions, except probably for Mexico City and more recently Uruguay. So there might be another trend brewing there. But what it's interesting in Latin America, similar to Europe, that once you open the gates to saying, well, even if it's within an exceptions framework, then you immediately can demand from the state, well, are you respecting this right? Are you protecting it? And what does it mean to fulfill this right? And that's where it is so powerful to bring the conversation of what does it mean to fulfill the right to health and to make it accessible and affordable. And in Mexico City, and Alejandro could talk about more of this, the implications for immediately demanding from the state free services for abortion, right? And so that's something that is still missing.
Can I get 1 minute from you, Alejandro, before we go on to the 1 minute before we go on to the commentators on this just this question?
I mean, Mexico City, first of all, I think is an exception in many ways. It's probably the most ambitious service provision, publicly funded experiment in history, at least in a democracy, I think. Of abortion. I mean, it was massive. It was from 0 to 100% of state hospitals providing this for free. Just getting the logistics of getting the pills on the ground was an issue. And there was a question of what to do with conscientious objection. And this is while the litigation was going on in the Supreme Court, this was being implemented. And the decision was very clear. It was make it a non-issue. generate as little friction as possible on any and all fronts so that you can actually implement the system and provide the service massively, quickly, and safely, so by the time that the court comes down with its ruling, a system has been set in place that has been working. And it was enormously successful in that sense. Now, that decision was made before the Supreme Court ruled that it was constitutional to decriminalize abortion through the legislature, and it was a decision meant for the concern was basically strategic for the litigation. What implications, have we set up a precedent of having too lax a conscientious objection in Mexico that may be harming the rest of the world? Maybe so, I don't know. But at that moment, it was an incidental decision that was crucial. And that's the tension between deciding the little tactical things and deciding the grand design over many years and seeing what happens over 30 years.
So we're going to move on now to the commentators. We have two commentators. And Susanna Mancini is going to talk first for about 15 to 20 minutes. Very good.
Okay, thank you. And thank you for having me here. I've been, learning very much since this morning. So, what I think these three papers altogether suggest is that conscientious objection, which is in theory grounded in freedom of religion and conscience, has really very little to do with conscience and religion, at least if we think about religion as an individual right. Now, let's take the example of Italy, which emerged from Christina's paper as one of the most problematic cases, at least among liberal states, with almost 70% gynecologists objecting. Now, in 2008, the then Minister for Health declared that the rather liberal regulation of abortion in Italy had to be rethought in the light of the government's strong pro-birth orientation that we pursue because the society we envision is a society of demographic rebalancing. Just incidentally, I would like to mention that in 1927, Mussolini, when he received for the first time a group of national delegates from the Fascist Party's women organization, told them, go home and tell the women that I need births, more births. Now, a very interesting poll conducted last year in Italy indicates that 77% of Italians are convinced that doctors do not refuse to perform abortions on religious grounds, but because of financial reasons. Abortions can only be performed in public facilities in Italy, so performing abortions doesn't help building you a career in in your private practice. Plus, abortions are increasingly the problem of migrant women, and or because they're will be marginalized in their career if they do and suffer career damages if they do not object. Interestingly, about 15% of those who responded think that doctors do not perform abortions because of their deep misogyny, so because they don't like women. Now, this explains why the fact that in Italy, like in Norway, courts have accepted that employment advertisement, hospital may require that doctors that apply for the job are willing to perform abortions has not solved the problem. Because what happens is that doctors are hired on the premises that they will not object, and shortly after being hired, they do object. At a point in their life when it's somehow difficult to think that they do this out of religious convictions. So what I think we should come to the conclusion that women's reproductive rights are sacrificed, really not in the name of religious freedom, but rather in the name of collective interests of actors that have a clear political project. Of course, this is not to say that religion does not play a role in this project, but to understand this role, one has to place it in the concurrent process of globalization and privatization that has led to an increasing blurring of the line between private and public. And in this connection, religion has become deprivatized in a trend that started, back in the 70s and 80s in very different countries like Poland, Brazil, the United States, many European countries. So deprivatized religion not only seeks an increased role in public life, but specifically in the political arena. Now, theoretically, this is a huge challenge because it really does question the essential tenets that animated the Enlightenment project, that is, acceptance of a clear-cut distinction between the realm of faith and that of reason, together with the commitment to ruling the public sphere according to reason. And, of course, equal liberty for all. At the practical level, the deprivatization of religion produces new conflicts, as the one we discussed this morning, having to do with like religious clothing in the public sphere, religious symbols in the public sphere. But it also increases the difficulties in solving older problems, such as the one we're discussing in this panel, the tension between religious freedom and reproductive rights on the basis of the balancing test. What European courts, when they have to deal with conflicting rights, do is recur to the proportionality analysis and balancing test. Now, for those from this country who are not completely familiar with this test, what courts do is first, where a limit is placed on a claim right, establish whether the limit furthers a legitimate aim. In the second place, the court considers whether the means chosen to achieve this aim are rationally connected to the aim. And in the third place, the court considers whether the measure is proportional, strictly speaking, which means that the court considers whether there are any less restrictive means to achieve the same objective and whether the benefits of restriction outweigh the harm. Now, it is pretty clear that even if you apply this test correctly, that is, balancing constitutional rights against other constitutional rights or constitutional values, there is a problem in that the test requires the injection of a significant element of value judgment, at least in determining what is legitimate and in carrying out the final balancing exercise. But in the context of the deprivatization of religion, what is happening is that courts in Europe increasingly balance clearly defined constitutional rights that are rooted in the Constitution against political projects and collective aims that are somehow camouflaged as individual religious rights. Now, these political projects are by no means only European, as we heard from Maggie, and actually it's interesting to see what is happening between the two continents. Lobbyists in Brussels opposing like sexual and reproductive rights are in close contact with U.S. neocon organizations. For example, one lobbies European Dignity Watch, which is an organization that monitors European institutions in the name of Western civilization-related values. The organization treasurer is the senior vice president of the Intercollegiate Studies Institute, which is a well-known, U.S. neocon wealth fund. Now, another important actor in this transnational movement is the European Center for Law and Justice, which is another Christian pro-life law firm associated to the American Center for Law and Justice, founded in the early 90s by Pat Robertson, who I understand is not particularly fond of the ACLU. And now, but the European Center is somehow more ambitious because while Robertson's wanting to counteract what I think he defined as anti-Christian bigotry in American society, the director of the European Center for Law and Justice wants a transnational alliance against secularism. And this alliance proved very successful recently in a case that both Fredericks and I have been working on, when the European Court of Human Rights reversed its previous decision, and upheld the mandatory display of crucifixes in Italian state schools. And this victory really was the result of the convergence of interests and actions between different components of this new anti-secular alliance, including American conservative evangelicals. And the litigation strategy was really based upon the success of American evangelicals. And obviously, I think Meg is totally right. This project is highly detrimental to freedom of religion. It's not about freedom of religion. It's about bringing Christianity, political Christianity, back at the center of the European social, political, and religious landscape, which, of course, strengthen the privileges of majority religions under the protective umbrella of the state and leaves those who are in real need of religious freedom, such as European Muslims, with very little protection. Now, in order to counter this project, what I think is key from a constitutional law point of view is to rethink the boundaries and the limitations of constitutional rights. Fundamental rights. Now, fundamental rights stem from the Declaration of the Rights of Man and the Citizen of 1789, which was set against the hierarchies and the privileges stemming from the feudal order. So, consistent with this, the Declaration stipulated that individuals are free and equal to one another. This morning, Professor Ahmed Anaid correctly pointed out that there is a paradox in the universal language of the Declaration in that rights were conceived only as the rights of citizens within the nation state. But the paradox of the universality of the Declaration language really somehow already starts within the nation state. It's not just a matter of political and geographical boundaries that non-citizens were excluded. Women were excluded from citizenship. Women were excluded from fundamental rights on the basis of their association with the private sphere. I think it's important to also point out that modern citizenship was born in a time characterized by faith in science. So medicine and science provided a crucial aid to the development of liberal political thought because their method could lead to a value-free, secular knowledge of the social and the natural world, which could displace notions of human nature based on metaphysical speculation and religious orthodoxy. So nature, not religion, came to define the role of men and women in the private and in the public sphere, and the separation between public and private became rooted in scientific notions having to do with female physiology that objectively justify the association of women with the private sphere. Moreover, since, let's say, the beginning of the 19th century, gynecologists became a branch of medicine separated from other branches of medicine. And interesting, this was not paralleled with the evolution of a complementary science of men. So women became a special group of patients and a distinct type somehow within the human spaces whose body was finalized to reproduction. And this is when really women's bodies became the exclusive domain of male gynecologists, which of course happened at the detriment of traditional midwives' knowledge, which was vilified and associated with non-scientific, popular subculture. And in this moment, when the fundamental rights of the citizen and men were proclaimed, abortion really became a state preoccupation. So women lost control over what was really considered mainly as a physiological process within their body, and the state, with the new demographic preoccupations associated with the birth of nation states, started regarding the fetus as not the property of the woman, but rather as a future citizen. And this is when abortion started to be regulated restrictively and with a clear preference for the fetus over the woman. And this preference was not really challenged until the 1970s under the feminist movement, when European and American courts at the same time started balancing between these competing rights, taking more into account women's fundamental rights. But women's fundamental rights are structurally ambiguous in regulating or in the regulation of women's freedom, especially in the field of reproduction, for the reasons I just very schematically pointed out here. Because fundamental rights have historically been the vehicle for the exclusion and the subordination of women, which was instrumental to the preservation of power hierarchies and traditional class distinctions, etc., etc. So this, I think, explains the difficulties that we encounter today when balancing reproductive rights against consensus objection. Consensus objection seems to me to be shielding today preoccupations of another nature that still have to do with the role of, basically with the role of women in societies and with the possibility to not to grant full equality to women, which is really the most revolutionary of changes because it does challenge power hierarchies and the real roots of subordination. So in this respect, I think that international human rights can be somehow an instrument to at least partially rectify some of the shortcomings inherent in fundamental right protections in the field of reproductive rights. Professor Anaim this morning said they are radical and subversive rights. And in this respect, I think somehow they are. Human rights are the rights of humans irrespective of their gender. They are declared in the UN Universal Declaration in 1948, when even if discrimination against women persisted in many constitutional states, somehow the intellectual difficulties in granting women equality could not be compared to the situation in the 18th century. All humans are equal irrespective of their gender. So even if human rights implementation depends to a very large extent on national authorities, I think they can help. The CEDAW committee, whenever it decides on abortion cases, takes into account the fact that abortion and other reproductive rights have to do with all rights. They have to do with the right not to be subject to torture and degrading treatment, liberty, equality, dignity, health, but also the right to work and the right to education, which are key rights if you want to empower women, and especially rural women and disadvantaged women. When they look at abortion in terms of discrimination that women suffer on the ground of gender, they use an intersectional approach, not to miss anything of the actual experience of discrimination that many women suffer. And they also use the anti-stereotype approach that Justice Ginsburg has been advocating now for decades. For example, there's a very famous case concerning a 13-year-old Peruvian girl who was raped, and upon discovering that she was pregnant, she jumped from the roof, and she was not treated because of the fact that she was pregnant, not to hurt the fetus. So as a consequence, she became paralyzed. And the CEDAW committee says, well, the reason why she was not treated is the pervasive stereotype according to which women are in the first place means of reproduction before being human. So what I'm trying to say is that international decisions have a very rigorous right-based approach to reproductive rights that could be imported successfully in national conflict, in national context, to better address consensus objection difficulties. And in fact, it seems to me that countries that are somehow more open to the international level, like Colombia or Mexico City, seem to, have developed some very interesting experiments in regulating abortion based on the fact that women are human and as such they are holders of rights. Why doesn't the European Court do well? It is really not a very successful story. Christina told us about a few cases. The European Court doesn't do equally well compared to the CEDAW committee, for example. Because I think a large part of the success of the European Council system for protecting rights is due to the commonalities among Western European countries regarding the philosophical foundations of human rights and the commitment to protect them. So, in other words, consensus has played a very important role and has also been a catalyst in the development of what is often regarded as the most of the world's most advanced system for protecting human rights. However, consensus has also played a very important role in preventing the court in Strasbourg from developing into a fully fledged counter-majoritarian body. The system of the convention, for those who are not too familiar with it, is based on subsidiarity, which means that the convention dictates that certain standards must be universally observed in all member states. But in the first place, it is the contracting parties, the states, that are responsible for securing the rights and freedoms protected in the convention. And in order to reconcile the tensions between the universality of standards and the subsidiarity principle, the court has developed the famous doctrine of the margin of appreciation. This doctrine grants contracting states a certain margin to apply convention rights in a way that is respectful of the local context. Obviously, this embraces an element of deference to decisions taken by the national institutions. And of course, not all of the rights protected under the convention are subject to the same scope of the margin of appreciation. The court would not apply the margin of appreciation in the right not to be tortured. So states cannot claim that in their local context, torture is not somehow assumed as something that cannot be done, and so they have it. That would not happen. But reproductive rights certainly are subject to the application of a very wide margin of appreciation because they are felt as not homogeneously structured across Europe. And of course, to grant a margin of appreciation to majority-dominated national institutions in such situations frustrates the international system and thwarts the effectiveness of the very idea of international courts as external guardians against the tyranny of majorities. And this is, of course, how this is the process that led the court to balance against the moral concerns raised by abortion in Ireland and reproductive and health rights of women, and render a particularly infamous decision, ABC v. Ireland, in which the court was satisfied that women that seek a therapeutic abortion in Ireland should travel to the United Kingdom. Of course, there is something to be said that this margin of appreciation doctrine has protected the court from direct confrontation with contracting parties. This is a weak court in terms of, the remedy, what can be done after the declaration of a violation by the court. So in terms of remedies, so the court has to establish its authority, and when establishing rights in a context of cultural controversy, the court is very much aware that if state parties and people start resisting the court's judgment, there is very little for the court to do, and the very authority of the courts would be undermined. Thank you.
Fred Geddix is now going to speak.
I'm really honored to be part of this conference and to be on a panel with such distinguished co-panelists. I'm always humbled as an academic to hear about activists who actually do things instead of talking about doing things or thinking about doing things. And I'm also pleased to be on the panel with Susanna, whose work in religious symbols I've read and admired. It does happen from time to time when I'm invited to a conference and I'm on the panel and I start thinking, why am I here? What were the conference organizers thinking? I'm a Mormon. I'm from Utah. I don't write on abortion. But I have written on the contraception mandate, and so I thought, well, that must have been what they were thinking, is at least that. And I do think that there is a somewhat more optimistic story to tell about reproductive rights or abortion rights, looking at it through the frame of the mandate rather than through the frame of abortion rights. Rights to contraception are not controversial in the United States, or I would venture to guess anywhere else. We know about how faithfully Catholics follow the teachings of their church on artificial contraception. I don't have the data, but my hunch is that evangelical women are much more likely to actually use emergency contraception than they are to tell a pollster that they will use emergency contraception. Even Mormons don't teach against contraception or even emergency contraception. And so I think it's actually quite interesting to think about the situation of religious institutions that are now embroiled in a battle against the contraception mandate without, I think, very much political support behind them. I think when one thinks, I guess I should also warn you, too, that I'm going to talk more about culture than about rights, although I think in the end the two are linked. There's been, I think, a long-term trend of organized religion in the United States and most of the rest of the West, and I apologize to most of the participants here because when an American law professor talks about the West, he's really just talking about Western Europe, and I don't know all that much about Western Europe, so I apologize for the U.S.-centric tone of my remarks. But at any rate, I think two clear trends are evident about organized religion. First is the dramatic growth of unbelief. That is true atheism, people who simply do not believe, from minuscule fractions 50 years ago to maybe as much as 10 or 15% of the population in the United States. And even more important than that is the growth of anti-denominational belief. Individuals who refuse to identify themselves with a religion, even as they claim to be believers, or individuals who, sort of in an interesting way, describe themselves as spiritual but not religious. There's a lot of reasons for this, which I don't have time to go into now, but I think the information explosion on the Internet obviously has fueled a lot of it. It's left organized religion and everyone else vulnerable to the dissemination of unsavory details about their behavior, both in the past and in the present. I mean, it's one thing to have to go dig it out of the archives. It's another thing to simply Google Catholic child abuse and have everything just pop up on your screen right there. And that's led to profound disillusionment, I think, especially among the young. And I think also the market for religion has changed. There simply is dramatically less demand, again, especially among young people, for large institutions to act as the mediators of truth about the cosmos. The focus of belief is now individual rather than institutional. It's immanent rather than transcendent. Religion has become a consumer good that people shop for rather than an account of ultimate reality that is represented to people by mediators between God and the population. And I guess to borrow a buzzword from Internet scholarship, organized religion in the West is experiencing a classic case of disintermediation. I mean, this is really nothing that different from people who now buy their drugs, including contraception, from a mail-order pharmacy instead of going down the street to an analog store. And there's simply no need for the store when you can access the source directly yourself. And so I think contemporary religious denominations in the United States and elsewhere in the West are experiencing, they see the current situation, what they are fond of calling secularism, as an attack. But it's really not an attack. I think it's simply the result of a long, centuries-old decline in the social and political place of organized religion in the West. It must be profoundly disorienting to have been in charge for centuries and to wake up one day and realize we're not in charge. Look what they're making us do. And I think one of the most interesting things about the mandate controversy is the loose way in which the phrase free exercise rights is thrown around. As others have adverted, since Smith and Lukumi, and really throughout most of the history of the United States, there has been no free exercise rights to exemption. There certainly are none now. And yet people, religious institutions and many believers continue to talk as if they're entitled to conscientious objection, constitutionally entitled. I shouldn't have to do this because it's against my religion. And I was struck by, it was actually a throwaway line by Shami Chakrabarty this morning about, at a certain point, pacifists just can't be in the military. And in a sense, that's what religious institutions are claiming today. Hobby Lobby, the most famous or well-known of the contraception mandate cases that are making their way to the Supreme Court. I mean, essentially, they're saying we should be able to go into public life and provide a secular service and employ thousands of people who do not share our faith. In fact, we're prohibited from discriminating on the basis of faith and hiring them, and yet insist that all this be done in accordance with our rather idiosyncratic belief about contraception, which, as I said, is not shared by the vast majority of American people. I mean, it's like a pacifist saying, I get to be in the military, but you can't make me shoot a gun. It's one thing to exempt pacifists from the military. It's another thing to say we must accommodate their desire to be in the military. Let me just draw a few, let's see. Always hard to do these things on the fly, I guess. I guess maybe I can just conclude this small portion with this and then draw a few parallels to the mandate and then close. When you're in charge of the culture, you don't have to worry about what the culture says because you're it. You don't need to worry about exemptions, and that was the case of organized religion for so many years. But at least socially conservative religion in the United States, and I think elsewhere in the West, is now distant from the culture. It's alienated from the culture. I mean, contraception is an excellent example of that. I think abortion is actually another example of that, although it's more highly contested. And so when you're alienated from the culture, you feel like a minority, even though you're a numerical and political majority. And so you have this odd circumstance in which Catholics and evangelical Protestants, who together must make up easily more than half of the population of the United States, are now acting like religious minorities and claiming that we need protection. From whom, I don't know, but they need protection. Let me just draw a few lessons from this and link them to the mandate and then to abortion rights. Religious liberty, I guess religious freedom is no longer a liberty right. It's an equality right. And what religious institutions are experiencing is sort of the reduction of their position of privilege to the same plane as everybody else. Religious institutions and believers these days should be treated no better and no worse than other institutions and individuals in a liberal democracy. So as a general matter, churches and believers who are engaged in public markets should conform their behavior to the public values that govern those markets. The Affordable Care Act's been enacted as a law. It's changed the baseline. It's provided that it mandates that if you provide insurance, you have to provide contraception without cost sharing. And the fact that this is unprecedented really is beside the point. It's been passed by Congress. It's been signed by the President. It's been upheld by the Supreme Court in surely an unexpected way, although Jack Balkin expected it because he advocated it. But nevertheless, it's been upheld. And so if you want an exception from that, it is an exception. It is exceptional. You're not entitled to it. You have to conform to what this now expresses as a public value. It should go without saying that those who work for the government should work for all the people of the government and not simply not be able to pick and choose based on their religions. I think neither institutional religion nor its members should expect others outside the faith to bear any significant costs of practicing and adhering to the faith. Again, it's one thing to exempt pacifists from the draft and therefore to increase infinitesimally the probability of being drafted and therefore being shot at and ultimately killed. I mean, there is probably some measurable increase in probability, but it's minute and small. It's another thing to say, well, my religion prevents me from supplying contraception, so none of my 15,000 employees should be able to receive the statutory entitlement to which they are entitled under the Affordable Care Act. That if you're talking about a regime in which religion is privileged, that might make some sense. But if it's a regime in which religion is equal, then that doesn't make any sense at all. It doesn't make any sense at all for individuals who do not belong to a religion to bear material costs to enable those who do to observe their religion. I guess at the same time, I would say that religious congregations should be afforded the social space to authentically live the teachings and the practices of their faith. And I actually think both the mandate and American constitutional law roughly approximate that. So religious congregations should be able to choose their leaders without interference from the government. We have a unanimous case which says, yes, they can do that. Some question about what a leader really is, but at any rate, the general principle is established. Churches should be free to develop their theologies without government interference, to govern themselves internally. We have the church autonomy cases in the United States for that. I think hard cases are religious nonprofits, especially large healthcare agencies that are religiously affiliated but really conduct themselves not much differently than for-profit corporate entities. I would be less inclined to give conscientious objection status to those sorts of agencies than I would to religious universities who are trying to build a certain kind of community and have a much more expressive element to them than the delivery of healthcare services. To me, the optimistic part in all of this is the optimistic part for reproductive rights, is that I think most religious organizations have not truly woken up to the fact that the culture wars are over and they have lost. That they're still, as I said, throwing around religious liberty rhetoric and now using it to attack something like contraception in which their own members are against them. I think they may well have overplayed their hand. And I say that confidently now, and then I start figuring out how to get to 5 votes in the contraception mandate cases, and I don't feel so confident. But anyway, on the law, I think they may well have overplayed their hand, arguing that for-profit corporations should be able to externalize the costs of religious practice onto people who don't believe in or practice those things. And that ultimately, I think, will reflect back on abortion and the abortion cases and conscientious exemption claims there. At least that's the story that I tell and the story I want to believe. Thanks.
We're going to take questions, but I want to ask one question that's related to a sort of little comparative discussion we had at the very beginning about the difference between a legal culture that begins with the assumption that the state is going to provide a wide range of social services and a legal culture that starts with a libertarian presumption. If the United States, in fact, had adopted Medicare for all, right? So
it nearly did.
Believe me, my former Senator Joe Lieberman had something to say about that. But if the United States had adopted it, then I take it that the issue of the contraceptive mandate would not even have arisen, because the government would simply have taken care of the question, right? So that the problem in the United States is only because we decided to continue to use the system whereby we have private companies paying a percentage of the insurance costs for their employees, and that gives rise to the conscientious objection, right?
Yeah.
But if that's so, then why isn't the solution to learn from Europe and simply to say that the United States should just pick up the cost of employee care for anyone who has a religious objection to paying for abortion or contraception or anything else?
I'm not going to argue with that. When I said as we nearly did, I was thinking of Johnson in the 1960s. And
several times, right? There were several moments in which it might have happened.
And if there's ever an example of sort of the peculiar, of an illustration of path dependency and how you end up in a strange place because of odd choices you make along the way, it's the American healthcare system. Clearly, this would not be an issue at all if we did not have this strange notion that the healthcare services should be delivered primarily through employers. So politics is the art of the possible, and I guess the only thing we can say now is that anyone who wants to run in the United States for political office based on adopting a European idea, no matter how good, is not going to be elected, and that's American exceptionalism at its worst.
But how does that affect the constitutional question or the statutory question? Isn't the response that would be made by someone who objects to having their employee contributions, like Hobby Lobby, used for either contraception or abortion, is that government has a less restrictive alternative? The less restrictive alternative is be more like Europe.
Well, it's never a less restrictive alternative for the government to spend more money. And it's particularly ironic that it's the conservatives who don't want the government to spend money who are arguing that the government should just pick up the cost of this. I mean, the very people who have enacted all the restrictions that Maggie told us about on abortion are the ones who are saying, hey, the government can just pay for it. Of course, knowing full well that is a less restrictive alternative only in the realm of some parallel universe that doesn't exist in the United States.
Christine, do you want to talk about a parallel universe?
It actually doesn't exist in Europe either. Because actually many countries in Europe don't subsidize contraception at all. So the state national insurance doesn't cover it. Some do partially. UK is an exception. They fully cover contraception. But also many countries don't cover abortion. For example, in Romania, one of the reasons that these hospitals that are claiming to institutionally object, one of their arguments is that, okay, yes, abortion is lawful in Romania, but because the state doesn't pay for it, only in cases when a woman's life or health is in danger, et cetera, we don't have a mandate to actually provide it because the state doesn't cover it. So they tried to get around or justify why there's an institutional objection, saying that they don't have an obligation to provide it based on the lack of state coverage. So there isn't, many countries don't cover abortion, and many more don't cover contraception fully.
So questions on really any aspect, including the conversations we had before the break and the commentators after the break. Yes.
I guess my first comment and question is about not.
Yes.
Yeah. No. Speak.
Sorry.
Actually, it's fine.
It's all safe.
It's safe.
Thank
But
you.
it's closed.
Except for the ice that was a bit slushy. Okay, sorry about that. My first comment and question has to do with belief, and I'm a little, there's no one on the panel who's sort of speaking from the religious freedom perspective, so I'm happy to, put that hat on for a moment or play that role. You had raised the question, Louisa, about people who object by day and practice by night, and how do you legally raise it as an issue? And I wonder why it wouldn't be simply an issue of sincerely held belief. How sincere is your objection if you're practicing by night? I think your issue would be more a pragmatic one. In all likelihood, more people would simply refuse to practice it by day or night if you went after them. But sincerely held belief, which is the Canadian standard, would seem certainly to address it from a legal perspective. But sincerely held belief is part of what's puzzling me about what I've been hearing here. We all know that there are idiosyncratic ways of practicing religion, every religion. And if a person refuses to eat pork, practically over their dead body, but partakes of shrimp cocktail, I'm talking about a Jewish kosher diet where shrimp and pork are equally forbidden in the same passage of the Bible, and there are plenty of people who do that. Who is it for us to say that that is not their deeply held, sincerely held religious belief? And if that's the case, who are we to say that people can't determine for themselves that being in any way connected to the provision of abortion, which for some people they do sincerely believe to be the same as the killing of a live human being, and if they sincerely believe that being in any way part of that, isn't that a sincerely held belief that needs to be respected? And I'd be really interested to hear what you have to say about it, because there is, I'm not sure that I understand, outside of those people who are fudging it for financial reasons, or who are fudging it for social reasons, or because of professional competence, and then I guess you need to find the workarounds. But for those people who sincerely believe that their direct connection or their very attenuated connection is a matter of, a violation of a religious obligation, how do we address that?
So would any of the panelists like to respond? Yes, go ahead.
Let me start first with the kind of the ACLU's perspective on that. We, unlike some of our coalition partners who'd say, if you don't want to do abortions, then be a podiatrist. We're not there. Mm-hmm. We actually would support narrowly tailored refusal laws that protect the rights of health professionals not to perform abortions if it doesn't jeopardize patient safety. And that what that means is you have to give complete information, you have to give referrals, and you have to do it in an emergency, which probably means you have to learn how to do it, right, so that you're ready for the emergency. But when you say, well, it may be sincere, even if it's attenuated, even if you're the person who admits them in the hospital or my delicatessen or something, how far away are we going to get? What I would say back to you is that, yes, there's the subjective component, in terms of faith that we want to protect, but there's also an objective component, which I think that we as a society or a court can actually evaluate, which is how much of a burden really is it on your religious faith? And if it's really part of, you're a delicatessen person and there's a public accommodations law, then, it's just not enough of a burden, really, for you to say, I'm going to pick and choose. And that's, again, a lot more true if you are, say, the police officer who's not going to protect the abortion clinic. Do we really want to have police officers picking and choosing, who gets public protection, and bringing that back to the health context? Again, in an emergency, for example, do you really want, you're bleeding out on the hospital floor, do you really want the staff to say, sorry, it's against my religious belief? I will end by saying, we just filed a complaint which was sustained by the pharmacy board in California, where the pharmacist would not fill a prescription for 3 drugs following an abortion. It was a painkiller, a limitation on bleeding, and an antibiotic. And not only that, but when the clinic called up because the poor teenager hadn't gotten her prescriptions and said, this Walmart, well, don't you have any other pharmacists on duty? She said, oh, they're all Catholics. Nobody's going to do this. So again, I just feel that it may be sincere. There's no question that pharmacist was sincere. But it is, at some level, you are just not fulfilling the ethical obligations of the profession that you've chosen.
Can I just throw one little thing in?
Yeah.
It seems to me there are at least 4 different pressure points in this conversation between you. One pressure point would be the question of whether a belief is sincere.
Mm-hmm.
The second pressure point would be the question of whether or not belief, even if sincere, has been significantly burdened. That is, you haven't really been burdened. You have a sincere belief, but it's not really been burdened. And the third would be the question of whether or not there's anything the government could do as an alternative to burdening your belief. It is it's easy for the government to route around the problem, right? That was my suggestion to Fred, and he said, and not in this lifetime, from the standpoint of the United States. And then the fourth, though, which is the one that you raised, is the question, it can either be understood in terms of the question of waiver or in the question of public duty. Waiver, you waived your right to object by entering into this side of the profession. Or public duty, which is different than waiver, which is that by deciding to become a doctor, or deciding to become a pharmacist, or deciding to be a person who's in a public place of public accommodation, you've assumed public duties like those of the state, or similar to those that have a public concern, and therefore you can't make a religious claim that you could have made otherwise, right? And so one way of understanding, so you're pushing at her from the sincerity angle, and she is pushing back at you from the public duty angle, and also from the idea that it's not a serious burden. Right. But I take it, Noah, you could easily argue that the question of whether it's a burden or not also has to be decided from the perspective of the believer. Don't you agree?
I think that's exactly my point. I mean, I think there's plenty of room, and similar to what Lucy was saying this morning about, needing to do fact-based, contextual, case-by-case analysis. I think that's where you have to go, certainly on things like the attenuated connection. I don't know that it's appropriate to bring in an objective component to the test of sincerity and of belief. I think that has to happen under a proportionality analysis. I don't know if it's relevant in the American legal context, but certainly in a Canadian context, and I think in the European context as well, I think it would be, perhaps fair for a court to say, too bad there are certain things you're going to have to do, but I think I believe that we have to start by saying your belief is your belief. You think that making sandwiches and putting an olive on top, for somebody who's providing, you're entitled to that. Later on in the analysis we'll say too bad for you.
Well, I agree with you in part. I mean, I absolutely agree with you that sincerity is an individual judgment. You can't second guess it by getting the rabbi to say, oh, no, that's not important. You certainly don't want a court deciding what, the religion really compels. I guess what I'm saying, though, is that the substantial burden, is it a substantial burden on that sincere belief? That's an objective inquiry that I think a court can make. And again, that's very much where the contraceptive mandate case played itself out in California, and we had the first of those laws. In fact, when the Obama administration patterned its mandate on Californians because it had been upheld in all of our courts, the Conference of Catholic Bishops said this is obviously inappropriate for the country, A, because it comes from California, and B, because it was written by the ACLU. We were very proud. But that's very much exactly what our court said and what the New York court said, which is, look, you're a business. You've entered into the secular world. You have, employees of different faiths. At this point, it is so attenuated for you, Catholic Charities. You've purchased insurance that some non-adherent is going to use off the job. That's just too attenuated. It's just too long a journey. And at the ACLU, and we support really rigorous protection for religious freedom, which is why we carved out actually the churches and the temples and the other organizations that are truly serve their own people, employ their own people, or engage in worship. But that I think that is an appropriate inquiry. The harder question, actually, Jack, is the one you asked, where some of our friends said, why isn't the less restrictive alternative here to have the state of California pay for the religious nonprofits? And what the court said back to that is, first of all, questioned whether there was a constitutional problem there of having the state subsidizing the religious views of some of these organizations. But more than that, that the compelling interest that the court assumed, even if it said if we did have a substantial burden, there's a compelling interest in women's equality. They said having the state pick up the cost of that does not address the fact that the employer is discriminating between the male and female employees. So I just leave it at that. And I am watching the U.S. Supreme Court with great anxiety. I have to say, in California, this was sort of laughed out of court. In New York, it was too. And it was not even controversial in terms of compliance. And I was really taken aback by the response in the country to the Obama contraceptive mandate, including from, liberal commentators, Mark Shields, like this is the end of religious freedom. So I'm not complacent that we've won the culture wars.
There you go. Louise, what do you think about that?
So I was just going to say on your point, if you don't
Closer to the...
If you don't have somebody make an inquiry about substantial, in something like these contraception cases, you automatically go to compelling state interest, which, the legal term I would have for that.
Can you explain this just just make sure that everybody understands what you're doing?
Sorry.
We're crossing different cultures.
So in the American system right now, the contraception cases are going, the real stake is the Religious Freedom Restoration Act, which is a statute, and there's, several prongs. I mean, the first prong is going to be in these first cases whether the for-profits are people for purposes of exercising a claim under the statute. Then it's, do they have a sincere religious belief? Is it substantially burdened? If so, is there a compelling state interest that's, with narrowly tailored means? If you don't, first of all, the word substantial has to mean something. And if you leave it to just mean what I say it is, you automatically go to compelling state interest, which in other contexts has been described as fatal in fact, right? Query whether it would be fatal in fact here, but we certainly know, 10 years ago, the American courts would not have considered saying equality for lesbian and gay people was a compelling state interest. Like maybe today they would, but I don't think they wouldn't have. And so it's a really serious issue. Yes, you want to respect a person who's there, but you have tremendous consequences for what you're saying. Just tremendous. And I'm sorry, I just don't think the deli is the same as the person. Think about what that means. I'm substantially burdened if I have to deliver my sandwich to Planned Parenthood. Anyway, but I was going to say something else about equality, but you can continue with.
No, but what were you going to say about equality?
Well, I was just going to say it's really striking, right? Several of you have commented how it's about patience, right? And then Susanna, you were really doing a quite lovely riff for women's equality as, a real issue here. And I just wonder, and I'm going to go back to Noah's point, which is when the doctor turns somebody away or refuses to provide an abortion, if you think about it in another context, if the doctor turns somebody away, say because the person's LGBT and you don't believe in lesbians and gay people, I think we understand that differently. I think people react to that differently, which goes back to the question about call it equality, call it discrimination. I think we have what you were talking about, a real lack of understanding or willingness to say that reproductive health care is in fact about equality. And I'm just wondering if you think we would be in a different place, or could we be in a different place? So that's one strand of equality you talked about, but you also talked about equality or non-discrimination vis-a-vis religion. One or the other, do you think is more fruitful as a sort of advocacy, academic angle to change the story we're telling? The story is, in the States, it's a bad story and it's just getting worse, right? You have individuals, you have nonprofit institutions, now you have profit institutions credibly claiming they're going to the Supreme Court. What's our best retort, our best approach of what you have embedded in what you're saying?
Now, before I get directly to your question, from a European perspective, we had a case concerning a teacher in Switzerland who did not want to take off the headscarf while teaching. And she was fired, and the European Court of Justice upheld the Swiss authorities' decision on the basis of the fact that having been hired by a state school, she had the duty to represent the secular values of the Constitution, and her headscarf had the values represented by her headscarf conflicted with gender equality, which is a fundamental principle in the Swiss legal system that schools somehow have to teach, even visibly and symbolically, to children. I don't understand how you don't apply, from the court perspective, the same pattern to conscientious objection. issues. In Italy, conscientious objection was introduced when the decriminalization of abortion took place, because doctors that had been working for years in the public system didn't have to feel forced to perform something that they would not want to do. But other than that, I think that the public service logics is the one that really applies. Nobody forces anybody to work in a public facility that is compelled by the law to provide abortions.
Can I ask you, so in the United States, the problem is most of this is not done by government agencies, but is done by the market. But is there not, in the European context, a way of thinking about an extension to these market actors, that they are performing some kind of public function or public service, or that their activities are, as we would say in the United States, affected with a public interest, so that the same logic would apply?
From this perspective, you might be better off asking Christina, who's much better than I am. I can tell you that it depends. But in the case of Italy, we have no alternative because it is the monopoly of the state to provide abortion services. So here there's no problem. Of course, the regulation is, when it comes from, for example, to faith schools, is very different. Because then a far more nuanced approach is required, and even if they do perform certain public services, conscientious objection applies far more generously.
Mm-hmm. Can I ask you about that? I mean, it just seems to me the problem in the United States has to do with all this is delegated to the private sphere, whereas much of this health policy is delegated to the public sphere in other countries. So what do you think?
I think in most European countries, it is a public service, and I think even if it's happening, even if there is a private institution, it could be considered as performing a public service. But it hasn't really arisen, or I haven't seen it, and maybe others know the European context as a controversial issue with private hospitals. And I'm sure there are growing numbers of Catholic hospitals in Central and Eastern Europe, especially in very Catholic countries, where it's kind of accepted that they don't perform abortions. And
now, is that because the assumption is that for the vast majority of people in the country, they have access to public care, and so that if you have a lot more money or you have some other, then you can get private care? Is that the reason for
It's
that
usually
logic?
an additional insurance that you take out to get a higher level of service. Sometimes, at least I know that's true in Sweden, where I live. Is like everything is provided by the public sector. There are private private institutions, health institutions, and you buy insurance to get really good coverage, not the average Swedish coverage. But I just haven't seen it raised, really. I don't know if you've heard of it, or Ava, I don't know if you've heard of it being raised. I know that it is an issue, like in Africa, for example, where the Catholic Church is stepping in, and Catholic institutions are stepping in for the public sector because of lack of money. They're building, I think, 1/3 of the hospitals in Kenya are Catholic-based, or in Nairobi. So I think in poorer countries it's probably more of an issue.
We have time for one more question, but yes, Fred.
I just wanted to answer Louise's question about what story you would tell. I would tell a very simple story, and that is that you should not have to pay for the costs of my religious practice. To me, that's the bottom line. And
but that can't work in many states where you have established churches.
Well, let me finish my thought, and then I'll think about your thought. And in the United States, private employers are a bottleneck. I mean, they function like monopolists. You can only get your insurance from the employer. And so if you allow the employer to externalize the costs of his or her religious practice onto employees, you violated that principle.
Okay, so we have two more questions before we close, one from Robert and one from Susan. Robert.
Mine is actually a linking comment that seeks to link panel 2 to panel 3 tomorrow. And that is because in the recent litigation on a claimed exemption from performing civil partnerships for same-sex couples at Islington Town Hall. The lawyers were relying on an analogy with the right to claim conscientious objection from abortion. So this has forced me to think a bit about what the two situations have in common. So three questions I think can be raised. One is there a limited category of acts that are potentially covered by conscientious objection? Is there some principle that would explain them? So if the two cases that are common in Europe are military service and abortion, well, you could say maybe this has something to do with terminating human life. And there are some in the UK relating to reproductive technology, working on embryos, etc. So applying that criterion, I'd say registering a same-sex couple at the town hall has nothing to do with terminating life. It tends to be quite a happy occasion. So doesn't fit there. Two, there's a question of limiting the objection to the act itself, so not the sandwiches from the deli. And this is a big issue in the U.S. with serving same-sex couples. Objections are being evoked by photographers, bakers, florists, etc. We had a dispute on that in Budapest at a recent seminar at Central European University, where on the one hand, my PhD supervisor, Christopher McCrudden, was saying, no, it's limited to the act itself, registering the couple, whereas, what was her name from George Mason University? Yes, Alvarez. She was militantly defending the florist, the baker, etc. So, and then finally, number three, I would say even if we say there's a category of acts and we limit the objection to the act, I would say your objection must be non-discriminatory. So we wouldn't say to someone in the objecting to military service, I'm willing to shoot people who are not white, but not white people. I'm willing to perform abortions on African American women, but not white women. Mm-hmm. Well, essentially, to me, that was Lillian Liddell's objection at Islington Town Hall. Her job was to legally register the relationships of couples. She was happy to do it all day for different sex couples. But when she was asked to do essentially the same procedure with minor differences in wording for a same-sex couple, she refused. So those are three reasons why I think the analogy can be rejected tomorrow.
That will be very interesting to see. Susan.
I have a linking question, but back to panel one. Now, as Maggie was saying, the ACLU is sort of on both sides of this issue, and will assert claims on either side. But as an advocate at this point, I don't much like the odds on the reproductive freedom side, because it seems to me, Fred, you were saying the Supreme Court has never really recognized a right to exemption. This might be the beginning. And so the reason that I'm concerned about this is I think that there's a pretty big thumb on the scale on the side of the religious claims here. And in the United States, we don't have much countering that because, as Louisa and Christina and others were pointing out, under American law, there is no right. There's only a negative freedom. And so, it would improve that side of the balance if the Supreme Court had not, in the abortion funding cases, say the only right that you have here is to have the government not get in your way. That sort of sets you up for, well, if it's only private parties getting in your way, no right, no harm, no foul. So that's a problem. That's not going to change anytime soon. So, Jack, you were trying to get us out of the balancing idea by saying, well, what if? What if it were just the government? Also not going to happen, right? So it seems to me the other way that you could rebalance this is by looking again at the claims of conscience idea. And my linking question is going back to what Alejandro was saying this morning, which I said to him reminded me of algebra. If you have two different values that you're trying to balance, the only way you can look at them together is to find the common denominator. So Alejandro was looking to speech this morning as the common denominator where you might evaluate that whole picture. It seems to me, and what I'm wondering is whether this would only be rhetorical or whether it would help, to say that conscience is not something that should only be on one side of the scale here, that there really is a common denominator, that both the exercise of reproductive freedom as well as the exercise of religion are both claims of conscience or self-actualization. And therefore, maybe this is just rhetorical, and I'm saying we should not be giving up the idea that conscience is only on the religious side as opposed to the reproductive freedom side. But Alejandro, what do you think? Does this help to kind of give us a common ground between the two claims and get us out of the idea that it's just a battle between two incommensurable things?
Do you want to address? No. Oh, all right. Oh, go ahead.
Well, that's a tough question. I've claimed before that there's an expressive and self-realization dimension to our own reproductive decisions. However, I do tend to think that, and specifically abortion, and this I have a very hard time disengaging from, is fundamentally about equality and substantive equality. So I have a hard time moving it towards conscience. I like the exercise, but because I think in the end it is, and it was mentioned by Margaret, the critique of Roe, and I think Roe is wonderful because it does speak of a fundamental right, and that has sustained 35 years of bombardment, and it's still standing. And that's what I'm afraid of in Mexico City. Mexico City has a wonderful regime, but it hasn't been spoken of as a fundamental right. And when it has been spoken of as a fundamental right, it's the right to health, not the right to choose. And the big issue, and this is the pre-Roe litigation, was that abortion is about equality, about women having access to the work market, women having access to decisions, etc. So maybe I'm betraying what I said this morning, but in this case, I have a hard time moving out of the equality because I've made such a point of, even privacy is not the point to me, and regarding abortion rights. So I can't answer that quickly. I need to think about it a bit more.
Can I just say something about?
So I'll tell you what. We have very limited time. Here's the way we're going to do it. We have 3 more people who get to speak. Christina will speak. Priscilla will speak. Noah, you're batting cleanup, as they say.
Thanks for your comment. And in fact, in fact, Rebecca Cook and Bernard Dickens at University of Toronto are making that claim, that providers have providers, those wanting to perform abortions, have a conscience, and that oftentimes, as we heard from Louisa and what we see in Europe, that it's the abortion providers that are starting to be ostracized. And I think Maggie mentioned that too. And so I think that's coming up, at least in academia. And in that Polish case that I was mentioning about the 13-year-old, we actually made that claim under Article 9, that she had a right to her conscience, that she believed that she should have an abortion and that she should exercise her right to conscience, and that it was in conflict with the beliefs of the hospital, and et cetera. Of course, the court never addressed it because it just completely ignored it, and we knew that it was kind of radical for the court to address it, but we felt like we needed to really make that claim. So I think it's arising. It's arising. And I wanted to just make one comment regarding the burden of proof, if I can. And this might raise a lot of discussion, but I think it's useful to look at the military context. At least I know in Europe, when someone wants to object or refuses to perform their military duties, there's a huge burden of proof on the person that is raising the conviction. They have to go before a panel. They have to prove that they're, and I'm not saying necessarily that the issues are comparable, but I think that it's useful to look at that, and it would be interesting to hear about how the reproductive rights groups and the groups working on conscience in the military worked on this Columbia bill that's pending before the Parliament there.
Just on the conscience point. Take another one here. Okay. On the conscience point, the Pope actually just gives quite a bit of credence to that idea in his recent interview, because he talks about women who come to a decision with their Holy Spirit and make the decision to have an abortion or to use contraception as being deserving of the respect and counseling and pastoral care of their priests. So even the Pope sees this decision as one of conscience and one of religious conscience made in conjunction with the deity. And I think that gives a lot of credence and a great bit of support to this claim that could be sort of rebirthed. I think it's good.
Poor Pope Francis. He's going to be in a lot of trouble soon.
He's in a lot of trouble.
Yeah, Noah.
Well, first of all, Christine, I think the idea of the burden of proof may be a very useful one that's worth exploring when we talk about any kind of conscientious objection if we're going to take it seriously. the question I wanted to answer was about the difference between conscientious objection in the abortion situation and in the same-sex marriage. Will I register it, or will I officiate it, or will I actually perform it? Scenario, which you and I will be talking about tomorrow morning. I think there's one other fairly significant difference. Government can get completely out of the marriage business if they want to. It doesn't have to happen in the public sphere at all. It could happen amongst consenting adults in a faith setting as a religious ceremony in its entirety. There is no analogous situation for a medical procedure, and I think that also makes things a little bit more tricky.
Lisa, you have the last word today.
I just wanted to go back to Luis's question on why isn't this issue being addressed as substantive, from a substantive equality perspective. And you are absolutely right. And this constant use of gender-neutral language, in the Inter-American Commission and in other documents is a reminder of that. I have very little faith that either the European Court of Human Rights or the Inter-American Commission or Court will address it from that perspective. Or the UN. And in the case that Susanna mentioned briefly around ABC versus Ireland, it showed us again how women's rights are just second-class rights within the European system, right? It's okay for Ireland to continue to have this only right to life exception when the woman's life is in danger and not say anything about her health, in a very restricted and so sad to bad. You can still travel, right? With which other right has the European Court said you cannot exercise it in your country? Cross the English Channel and exercise it, or with no other right. So it's a reminder of that. But CEDAW, the question there is CEDAW. We have brought two cases, one in the context of safe pregnancy and what the government needs to do to ensure that women don't die giving birth, and the other one, the LC case that you mentioned with regard to what happens with abortion services. And CEDAW has started to say, well, it is discrimination to deny women services they only women need. So it has just, put it within a completely different from the other systems framework. And the interesting question could be for CEDAW, if a case where conscience as an obstacle to fulfilling women's rights, reproductive rights, how could it unpack what the concept of substantive equality under CEDAW could mean? That is the only hope that I would have in terms of addressing it from that perspective in the international realm.
My conscience compels me to tell you that we are out of time. Thank you for a wonderful panel.